a series of basics of interpretation of statutes. In this video, we will talk about the operation of a law. Now, we will cover this topic in two parts. The first part will talk about date of enactment and date of enforcement and the difference between the two. And the second part will talk about prospective and retrospective effect of a law. Now, the procedure of lawmaking is that the law needs to be introduced in any house of the parliament, or if we talk about state law, then any house of the state legislature. Then the bill needs to be passed by both the houses, and later on the assent needs to be obtained from president at the center level and from the governor at state level. Now this whole procedure needs to be followed. Now before the assent of the president, the law is called a bill, and after the obtaining of the consent of the president or the governor, as the case may be, the bill comes to known as act. Now, the date on which the president or the governor grants his assent, then that date is called date of enactment. For example, Bharatiya Nyaya Sanhita 2023, it received the assent of the president on 25th of December 2023. So that date is the date of enactment. Second date is date of enforcement. Now, merely obtaining the consent of the president or the governor is not sufficient. To apply that law to the people, we need to notify that law in a gazette also. Only after notification it will come into application and will apply upon the people. Now, notification is a notice to all the people that this law will come into force on such a date. That's why notification is important. The presumption that every person knows the law of the country will start apply upon people from the date of enforcement. For example, in the case of Bharatiya Nyaya Sanhita 2023, the date of enforcement is on 1st of July 2024. I hope you understand the difference between date of enactment and date of enforcement. If we look at the bearing, then the date of enactment is given at the top, whereas date of enforcement is usually mentioned under section 1 of the act. Now, sometimes the date of enforcement is not mentioned at the time of enactment of the law. In that case, it is later on notified. In that case, you will find the date of enforcement in the published Bear Act. It means the Bear Acts which are published by the publishing houses. In that case, you will find the date of enforcement in the footnote. Now, we come to know that the law will apply from the date of enforcement. Now the question arises whether the law will apply to the acts which occurred after the date of enforcement, or whether it will apply to those acts also which occurred before the date of enforcement. It means if we talk about Bharatiya Nyaya Sanhita, then question arises whether Bharatiya Nyaya Sanhita will apply to the offences which occurred after 1st of July 2024 only on those offences, or it will also apply on the offences which occurred before 1st of July 2024. Now, to remove this confusion, we have a concept of prospective and retrospective effect. Now, the prospective effect says that the law will apply to the acts which occur after the date of enforcement. It means to the future acts. That is called prospective effect. Whereas retrospective effect means the law will apply to the acts also which occurred before the date of enforcement as well. It means if the law comes into force on 1st of July and the effect of the law is retrospective, in that case it will also apply to acts which occurred before 1st July 2024. Now, the question arises how we will determine whether the law should be prospective in nature or retrospective in nature. To determine it, the first rule is that the law itself mentions that whether the law is prospective in nature or retrospective in nature. The apt example of it is section 358 of the Bharatiya Nyaya Sanhita, because it mentions about the prospective and retrospective effect of the law. Now, second rule says that if the law is silent on this aspect, it means it does not mention whether the law is prospective or retrospective in nature. In that case, Article 20 Clause 1, which deals with ex facto laws, which says that all the rights and liabilities of the person will be determined by the law which is enforced on that very day. It means the future law will not determine the rights and liabilities of the person. Now, a commentary on Article 20, Clause 1 lays down about prospective and retrospective effect. It says that if the law is substantive in nature, it means it talks about rights or liabilities of the person. In that case, the law will always be prospective in nature. Secondly, it says that if the law is procedural in nature, it means it merely tells how the things needs to be done. For example, the format of FIR, how to issue summons, what should be the format of warrant, or to file a suit. These are procedural aspects. And if the law is procedural, in that case, the law will get retrospective effect. But the second rule applies only when the law itself is silent on the effect of the law, that whether it is a prospective or retrospective effect. If the law itself mentions that the law is prospective or retrospective in nature, in that case, the second rule will not apply. I hope this video helps you to understand the effect of prospective and retrospective effect. For more such videos, please like, share and subscribe to the channel.